In California law, voluntary manslaughter is when you kill somebody in the heat of passion or in a sudden quarrel. Now, the prosecutor very rarely charges somebody with voluntary manslaughter in the first instance. What usually happens is the prosecutor charges someone with murder, and the person accused of murder says, well, I killed the person, but it wasn't murder, it was really voluntary manslaughter. The difference is really in the sentencing. If you're convicted of murder in California, the sentence is life in prison, and people are very rarely paroled, so it's a life sentence. But if you're convicted only of voluntary manslaughter, then the sentencing range is 3 to 11 years. Sometimes a little more if there's a weapon involved, but it's a much better result for the person than being convicted of murder. So what does it take to reduce a murder charge to voluntary manslaughter? You have to show that the killing was in the heat of passion. Heat of passion means that there was some adequate provocation that caused you to lose control. And it's a sort of provocation that would cause reasonable people to lose control in that situation. The classic example that is given in law school and that lawyers talk about and judges talk about is a man who comes home, a married man, who comes home to his house and he walks in and he sees his wife in bed having sex with some strange man. And he goes ballistic. He loses control. He loses all rational thought and he kills this stranger. Well, it's not self-defense because the stranger was not threatening him, but it is voluntary manslaughter because he had lost his rational thinking, he had lost control, and he killed in the heat of passion.